I'm Luke Clements. I run a research centre at the School of Law at Leeds University. It's funded by disabled children's charity, Cerebra. I was a solicitor for 40 years, although in the last sort of half of that, I took refuge in academia. And for the last 10 years or so, I've been based at the School of Law at Leeds. And Cerebra basically funded the work to overcome commonly occurring problems that disabled children and their families experience in accessing their legal rights, particularly to social care, which is the topic I'm going to be talking about today. We've done a whole series of research reports on things ranging from disabled facilities grants, direct payments. We're doing a lot of work at the moment on fabricated and induced illness and general parent blame approaches, but the research materials I'll show you how you can look at those. And those look across the whole of the United Kingdom generally. Sometimes we only focus on England. So what I'm talking about is a broad range of problems that are not necessarily local, because I don't really know what happens in this particular region. As I've said, I'll talk you through the program when I put the PowerPoint up in a minute, and then either as I'm talking, unmute and interject if there's something really pressing, or put it in the chat function so that Sarah can then relay it to me. Whilst I'm presenting, I can't actually see the raised hand logo normally. Sometimes it seems to work. So that if you have raised your hand and I'm not doing anything, it's possibly because I can't see it. So either unmute and interject or make a note and ask Sarah to interject on your behalf. So let's see if I can get this PowerPoint up. Hopefully you can now see the PowerPoint and just the first page, which says disabled children in the law. Can somebody just confirm that you can see that?
Yes, we can see that, Luke. Thank you.
Great. Okay. I've sent Sarah a copy of the handout for that PowerPoint. I hope I have, Sarah. I think I have. And that
yes, you did, Luke. I sent it out this morning.
Oh, brilliant. So everybody should have a copy of that. And if you haven't, then if you're in the chat function, you can mention that. Sarah, I'm sure, will sort it out. So at the bottom left-hand corner of that slide that you see now, you'll see I've got a website. And if you go to that, I put a lot of commonly occurring problems on that site because I do tend to get an awful lot of emails, which I can't really cope with. So normally I try and just direct people to resources that have notes about what to do in certain situations. And so it's useful to sort of scroll down those. And often I'll be referring people to that. Challenging, direct payments are causing quite a lot of problems. We'll look at those today. Care package cuts obviously is a big issue with austerity. Funding panels I'm going to be talking about today. Lots of sort of different things. A lot of the materials I've done recorded lectures, so they're on that, and they cover a whole range of issues. They're normally really badly filmed because I do that and I'm technologically incompetent, but there's a lot of detail in about a dozen or so brief talks. If you go to the publications tab, you'll get my recent publications, and on most of those you can just click on and download the material without any problem at all. Some of those, like the book Clustered Injustice, is only for sale. It's not very expensive, it's not very big, but that's not free of access. But if you scroll down, you'll see there's a book, for example, there, the Disabled Children, a legal handbook that I've co-written with a colleague, Stephen Broach, who's a barrister. And the Council for Disabled Children have paid for that to be freely accessible online. It's over 600 pages long. And if you click on that, you'll get that whole book. You get all the individual chapters of that book. There's chapters on social care, education, health, discrimination, transitions, and so on. I fairly frequently do a book on carers and their rights for Carers UK. It's over 100 pages long. That again, you can just click on as you scroll down that page, and it's got a lot of detail. We'll be looking at today the rights of parent carers and the rights of young carers briefly, but there's a lot more in a book like that. The work I do with Cerebra involves commonly occurring problems and how you, as a parent of a disabled child, can access those rights without having a sister who's a barrister or having the networks to do that. And there's a 36 or so page booklet on accessing with commonly occurring problems. We divide all the problems that we see in social care into 9 categories. And then each of those categories we explain, this is the approach we would advise that you took in that case. And at the back, there are precedent letters. And that, I think, has been downloaded over 60,000 times. So obviously is of some value. And that's the recent book I've written on clustered injustice and the level green. So today I'm going to be looking at these key issues, just a general overview of social care law, how authorities legally should assess a disabled child's needs, what an assessment really should look like, what it should contain, and what it should address. Then I'm going to look at the eligibility decision, what the law says about deciding whether a disabled child is eligible or not eligible for support. And then looking at what types of support can be provided, the range of supports laid down by the legislation, the Care Act 1989 and the Chronically Sick and Disabled Persons Act 1970. And then at the end, I'll look at parent carers and young carers, the rights to be an assessment and to support. I think we've got another session planned, haven't we, Sarah, for a couple of months hence?
Yes, we do, yeah. Thursday, the 18th of July.
Okay. And then we'll be looking at things like transitions, I think, the rights of young adult disabled people and their carers to support. So what happens after transition and once the young person and their carers are in touch with the adult social services team. I think we may be looking at briefly at capacity issues then, and also law reform, because one of the things I'll be saying today is that the law is a bit of a mess. It gives very good rights to families, but it is unnecessarily sort of complicated, and the Law Commission is currently looking at codifying that and simplifying it. Okay, so I'll plow on. So the first thing I talk about is assessing need. And assessments are really the core function that local authorities do. They spend a lot of money and time assessing needs, probably more money and time assessing needs than actually meeting those needs. And assessment process is something that happens in all of social welfare law. Doctors assess whether people need resources from the NHS. Lawyers assess whether people are going to access legal aid, which is a resource. Obviously, special education needs tribunals, and assessors do that. And in social care, it is the role of social workers to decide whether somebody has, or not necessarily a social worker, but a social care practitioner, whether somebody has needs that require the authority to put their hand in their pocket, basically, and apply resources to that situation. So assessing is core. When I used to do a lot of judicial reviews on this area, I used to estimate something like over 80% of the judicial reviews turned on whether the assessment was adequate or not. So assessment is really the engine of social care, and it's got to be got right from the local authority and from the family's perspective. In reality, it's a very simple assessment question. And that question is, what if? What if the authority doesn't provide support? What will happen? And the more serious the consequences, the more difficult it will be for the local authority to say no. The more difficult it will be to find really compelling, cogent reasons as to why support is not necessary. And so during an assessment, it's up to the family basically to provide evidence as to what is likely to happen, not just necessarily immediately, but in the short and medium and long term, if resources aren't made available, and to then spell out what those support needs are. And the law frames that very much in terms of negative impacts on well-being. And well-being, of course, includes physical, mental, and social well-being, but it is wider. And as we'll see, it includes well-being for the carer, the carer's right to engage in employment, to work, to study, to get further training, as well as having leisure and social activities. So it's a very broad concept, and the law is framed very rights-based terms. So the problem in social care is not really the law. In children's social care law, it could be simplified a bit, but the law, once you understand it, gives very good rights. The problem, of course, is that Parliament has willed that end, but the government hasn't willed the means, the financial means, to local authorities to meet those obligations. So what I'm doing initially in this talk is to talk about what should happen in an ideal world. Effectively, an assessor should come along and ask what will happen, what the needs are, and what will happen if those needs aren't met. And the more serious those consequences are, the more difficult it will be for the local authority to give rational reasons for saying no. Once the local authority has decided that there is a requirement, because there's a significant risk, short, medium, long term, to the family's well-being, not just the disabled child, but their siblings and their other family members, parents, then the local authority has got to spell out in detail in a care plan what support, what quality, quantity is going to be put available. And that is really another question. That care plan answers another question, and the courts often talk about care planning as the how, who, what, and when. It's the fine detail of how this need, let's say for the parent to have a break so that she can stay and work, or she can look after her other children, or take part in recreational training or education or some sort of community activity, how that can come about. Well, that will need somebody to be looking after providing support perhaps for the disabled person. So who's going to do that, how they're going to do it, when are they going to do it, how often they're going to do it, what are their qualifications, and so on. And that's the detailed thing that should be in a care plan. I'm going to come back to that, but that's effectively what an assessment and care planning process should look like. So these rights are particularly reserved for disabled children. And there we run into a problem, not in the definition, because the definition of a disabled child is very wide. We run into a fundamental problem with the Children Act, which in my opinion was a backward step for disabled children. Because the definition of a disabled child is wrapped up with, unfortunately, the definition of a child suspected of neglect or abuse. And that creates problems. So the Children Act places a duty on Children's Services Authority to protect, to safeguard and promote the welfare of children in need. Not all children, just children in need. So we then ask the question, what is a child in need? What's the definition? And as I've said, the Act unfortunately defines that in two different ways. A child is in need if they're basically at risk of neglect or abuse, or they're experiencing neglect or abuse, or if the child is disabled. Now, those are two very different groups of individuals. Of course, some disabled children are neglected and abused, but not many. The vast majority are not. And you're mixing up sort of chalk and cheese, pears and apples. And that is causing, as our research shows, major problems. And we're asking for disabled children to be taken out of the children in need definition, to have a completely separate set of rights. Because in practice, local authorities are really focused almost exclusively on neglect or abuse. Only 2% of disabled children within the average local authority area are getting support from a disabled children's team. They're the Cinderella area compared to the amount of resources applied for children who are considered to be at risk of neglect or abuse. The definition of a disabled child is very wide. And the definition is in the Children Act 1989. And it's a pretty old-fashioned definition. It'll have to be amended when the new law comes in. But that's the definition now. Sometimes local authorities seem to say, well, we don't like the Children Act definition because it's old-fashioned. It's what is it, 35 years old or something like that. Well, you know, there's lots of old law. The Homicide Act is an old act, but it's still an act, and this is the law, and you apply the law as it is. Sometimes local authorities say, well, we'd like to use the definition in the Equality Act or something. Well, they just can't do that. That this is the definition laid down by Parliament. And it says that a child is a disabled child if they're blind, deaf, dumb, or suffer a mental disorder of any kind, or is substantially and permanently handicapped by illness, injury, or congenital deformity. Now, those are words that we wouldn't use today. We wouldn't talk about somebody being handicapped in that context. We would talk about somebody having an impairment. And because of the way society is structured, that handicaps them. They have an impairment, they can't walk, and they are handicapped by the fact that everywhere they are confronted by barriers and steps. They don't have ramps or lifts and things like that. So it's a form of language we wouldn't use today, but that's how it is. And the Act defines somebody as being a disabled child if they have a mental disorder of any kind. So what is a mental disorder? Well, that's defined in Section 1 of the Mental Health Act. And that says a mental disorder is any disorder or disability of the mind. So a mental disorder would be obviously a learning disability, a mental illness, but autism would be a mental disorder. Attention deficit hyperactive disorder would be a disorder. And we'll see that that's a very wide group of people. That's what Parliament has said. That is the law. Local authorities in some parts of England have tried to narrow that definition down, but they can't do that. We can't say that the law laid down by Parliament doesn't apply in Sussex or Yorkshire or whatever. That's what the definition is. So somebody with high functioning autism with a high IQ will prima facie, you know, on the balance of probabilities, be a disabled person. So because they have a social, effectively, disorder in the sense of the sort of they're neurologically different, effectively, to the sort of the norm, and that's in a way how disability has to be defined. And once a disabled child meets that definition, they're a child in need and they're entitled to an assessment. Just as once a child there is cogent evidence that they're going to be that there's a risk of neglect or abuse, they meet the need. There's got to be evidence that they meet the need. There's got to be evidence that a child is disabled, but that might simply be by observation. What you'll see in this definition, and going back to it, there's no requirement there for a diagnosis. And of course, a diagnosis would be really difficult because that's a medical test, and the whole move in social care is for a social model of disability, not a medical model of disability. And the House of Lords, now called the Supreme Court, has said that disabled children who meet that are entitled to an assessment. It's repeated in the Care Act, particularly in relation to the rights of parent carers. Anyone caring for a disabled child has a right to a parent care needs assessment, and we'll look at that later this morning. And people under 18 who care for a disabled child have a right to a young carers assessment. And if support is required, then there are a whole set of statutes. Well, there are two statutes, the Care Act 1989 and the Competency and Disabled Persons Act, that says these are services simply for disabled child. They're not there for children suspected of neglect or abuse. If once a child comes into the category of a disabled child, then there's a whole range of services reserved for that child and their family.
Sorry, Luke, can I just jump in there? There's one question in the chat from Leslie. It says, is child defined by age? Does it cover disabled young people up to 25 years?
No, in social care, it's a child, which is the usual definition, which is up to the age of 18. So the Children Act and the Chronic Sick and Disabled Persons Act apply to the age of 18. Once a young person becomes 18, then in general their needs are met under the adult legislation, which is the Care Act, which is exactly the same. I mean, the processes are slightly different, but the obligations are the same. So when you get to 18, there's a handing over of the baton. Now, what we'll see when we do the next session in July is that the obligations of children's services don't stop immediately on a child's 18th birthday. They can continue until a convenient moment arises for the baton to be handed to adult social services. But when we're talking about a child, we're generally talking about somebody under 18. Of course, the special education needs legislation can and very often is extend the responsibilities for education until 25. But at law, a child is somebody under 18. Does that answer the person's question? If not, they can chip back in. Is that okay?
Leslie, does that answer your question?
Okay.
Yes, thank you.
Okay,
Yes,
thank
you.
Thank you. So when we're looking at an assessment, it's a question of working out exactly what the needs are. And therefore that must be a face-to-face, fairly thorough assessment, and we'll come back to that. But the Ombudsman said that an assessment must carefully and accurately set out the young person's needs. It must be sufficiently detailed so a proper decision can be made as to what services, if any, are required. And if services are required, these must be specified. What actions to be undertaken by whom, for what purpose. If support's required, then it must be explained what the assessed hours will be that will meet the young person's needs. And if support isn't required, then the local authority must give clear reasons as to why there's no eligibility, because the family could then challenge that. So I give you on these notes, and if you just Google those, you should get it. If there's a problem, I've kept copies of all of these Ombudsman's reports. The High Court has said that an assessment must demonstrate that it's been undertaken with the necessary rigour and width. Doesn't mean that a local authority is obliged to provide support, but it's required to make a rational decision as to what, if any, support is necessary and appropriate to meet the child's needs. So this is not a tick box exercise. This is one that has got to be sort of carefully considered and delivered. So that's what should happen in the ideal world. In practice, there are problems. And I'm going to look at some of the problems, particularly problems that have been researched, that have been identified by research. And our research is based on what Cerebra's members, Cerebra, a charity for disabled children, members say. And they've got many thousands of members. They contact an advice line. We at the university are in touch with the advice line almost daily, almost weekly, and we have meetings every other month. And we then scrutinize prevalent problems, things that are coming through the advice line a lot, and then we research those. So these are problems that we haven't just on whim investigated. They're problems which we have good evidence are systemic problems. So the first problem we've looked at is that some authorities, in our opinion, unlawfully discriminate by distinguishing between some impairments and others. So some disabled children, there's not a problem, but others, the local authority says, well, if you've got this particular impairment, then we want extra evidence. And particularly that are young people with autism and or attention deficit hyperactive disorder. And in those situations, the local authorities will say, well, you can't have an assessment if you present with autism or ADHD unless you've also got a diagnosis, or you've got to have a diagnosis and a severe learning disability, or simply you've got to have autism plus a severe learning disability, or you've also got to have severe challenging behaviour. So what these authorities are doing is they're adding additional hurdles for a disabled child to cross in order to access their legal rights. But that isn't in the legislation. The legislation simply says if you're a disabled child, you have a right to these assessments. If you've got autism, then not all autistic children are going to be disabled, but the majority of them are going to come within the definition of disability. We all know that getting a diagnosis for autism can take years. The research shows that over 50% of autistic children don't have a learning disability, and very large numbers of them don't have severe challenging behaviour. So these are effectively unlawful barriers that local authorities are erecting. And we did some research on this called Autism Plus Policies. And we did that with Yorkshire BBC because there was a problem in Yorkshire then. Although we understand the relevant authorities changed its policy, we're not convinced that all the local authorities that have, since that report was published, although they may have changed their policies, in practice, we get evidence that the problem is still occurring. A second problem that we encounter is some authorities refuse to assess a disabled child until they've tried short-term support. Early help, it's called often, and they've gone on a parenting class. And what in those situations you're getting is the authority saying, well, we'll only assess you, but we'll come to your house, and maybe we'll come to your house on without warning or with very little notice. And then when we're discussing what the disabled child's needs are, we want to look at the disabled child's bedroom, and we want to interview the child alone. And the question we as lawyers ask is, well, why? Because that's actually quite serious, a very serious interference with their human rights, with the family's right to respect for its private and family life and home. and state officials coming into people's homes and doing these sort of things should only happen if there is cogent evidence to support that. Police officers can't just walk into a house and then say, well, whilst we're here, we want to look at this, that, and the other. That's a severe violation of private and family life. So what we're asking then is, on what basis, why are a child who's never met this person before, who has quite serious social difficulties, being required to speak to this stranger alone? Why is the mother required and the family required to go in somewhere else? What is the basis? Well, what basis about this particular family led this state official to go up and inspect their bedroom? These are severe violations of private and family life. So we've done research on that. We locate the problem there with guidance that local authorities are really required to follow, known as Working Together, which was issued by the Department for Education. And we've said that's got to change. It's unlawful. It's mandating serious intrusion, demeaning, humiliating, very distressing situations sometimes, where there's no evidence for the state doing these things. And treating disabled children as if they are neglected or abused, which is what's happening. I mean, obviously, if there is evidence that a child is being suspected of neglect or abuse, if there's real evidence about that, then of course, speaking to the child alone or inspect the bedroom may be a natural thing to do. Just as if you suspect somebody, a youth in London, a black youth in London, that you've got evidence that they are acting in a criminal way, you can stop and search them. But you can't just stop and all black youths in London and stop and search them without evidence. But that seems to be happening in some parts of the country in relation to social care. We basically said that is a severe form of discrimination, and it's unlawful. And we did a report 3 or 4 years ago called Institutionalizing Parent Care of Blame. And we're pretty sure that that's going to lead to a severe revision of the Working Together guidance. The government's basically accepted that this is a problem, but in the most recent iteration of Working Together, it didn't change the requirements on local authorities. But I think there was every expectation that this would change this year. But of course, this year is going to be an election year, so again, it may be delayed. There's very likely to be litigation if it isn't changed. Because what we're seeing is this problem I've already identified at the beginning is mixing up disabled children with children who are suspected of neglect or abuse. They're two very different groups. In theory, what should happen in practice for a disabled child is that they should be referred to a team that has expertise in disabled children's rights and also expertise in how disability impairments present themselves. And that's the law with adults. If an adult is assessed by adult social services, the assessor must have that impairment-specific expertise or be able to contact somebody who has that impairment expertise so that they can advise on the appropriate process. That doesn't exist extraordinarily for disabled children at the moment. So there's no requirement that the assessor has expertise in the relevant impairment or has access to somebody who can help them with that. But in practice, that should happen. Not necessarily disabled children's team, but just somebody who has the expertise or has access to advice on the impairment, because some impairments have very unusual responses, and many disabled children with autism, for example, do what I'm sure you all know, mask their symptoms. so that they might appear to be fine, for example, at school, but actually they are suppressing everything just to not be out of line. And then when they come home, they blow up. So it's understanding that these are specific difficulties. So the assessment should be by a practitioner that has expertise or access to expertise concerning specific impairment. That should then decide if the young person does have any support needs, that those support needs should be put in. And those support needs won't be short-term, because disability is not generally a short-term issue. It's normally a lifelong issue. So we're going to be starting the assessment process on the basis that this is a long-term process plan. And therefore we will put in support, but we will have a review after 3 months and then annual reviews thereafter. And if at those annual reviews it's seen that the care plan isn't really working, then the plan will consider changing the support, increasing the support, maybe targeting it slightly differently. And then when the young person gets towards 18, there will be a review plan that will prepare for transitions and handing over the baton to adult social services. And hopefully those two processes will be aligned as much as possible. But in practice, those processes aren't aligned, because in practice, disabled children are not being assessed that way. They're being assessed under child protection. And that's a huge difference when a disabled child becomes 18. Instead of the assessment being all about risk and protection, they then become focused on needs. So the adult care and the social care assessments are very different, even though we're really just talking about disability in both cases. Because in practice, what the vast majority of disabled children experience is not an assessment, as I show on that right-hand column of the PowerPoint you're looking at now. They experience one by a generic child in need early help team. All children in need are pushed down that route, but the vast majority of those are going to be children for whom there is evidence of neglect or abuse. Only about 9% of all local authority assessments concern a disabled child. And that team is going to be looking, following a hymn sheet that is based on spotting children who are at risk of serious harm, significant harm. They are looking at short-term interventions to correct poor parenting in effect. So that the early help team, the child in need team, may only be able to give short-term, let's say, respite care, and that may only be conditional if the parent goes on a parenting course, as if disability is caused by the family rather than the social context in which disabled people have to live their lives. And if that limited intervention, parenting classes and all that just doesn't work, then the local authority will up the safeguarding ante and consider safeguarding. And if that doesn't work, then the child might become a looked after child or through Section 20 of the Children Act or in care proceedings. These are two very, very different routes. And they need to be separated. And the reason they're not separated is because the legislation, in a way, lumps disabled children and children at risk of neglect or abuse into the same group. And our critique of this it is not sort of something that we've met any resistance from really, well, from the majority of quarters. the major independent review of childcare, the McAllister review that has come out recently. In one of its interim reports, Josh McAllister said, a consistent theme in what the review has heard is that families with disabled children felt that they were navigating a system that is set up for child protection, not support. And the chief social worker for children and families at the Department of Health, in her report, she said, even where the sole reason for contact with children's social care was because the social care needs of an autistic child, there was a tendency to use the social work assessment as an opportunity to judge parenting capacity through a child protection lens rather than a lens of social care need. This has long been a complaint of families caring for disabled children. In the SEND review, a couple of years back, the final report said, some families with disabled children tell us they're put off seeking support from children's social care because of the fear that they may be blamed for the challenges their children face and treated as a safeguarding concern rather than receive the support they need. So that's, going from, what should happen in practice, that's explaining what the problem is. And the problem is largely caused by the Department for Education, although local authorities can handle this much better. They do have quite a lot of discretion, and some do much better than others. Now, everybody's been incredibly quiet, and I'm rattling through this. So I don't know if there are any comments or issues that anybody wants to raise, or if there's anything in the chat, Sarah.
Yes, there's 2 comments in the chat, Luke, that I was waiting to the end just because they weren't direct questions. So the first one was from Rob. It says, I know of someone who was accused of educational neglect because the child couldn't attend school due to unmet needs. There was even a police officer involved stating this was neglect.
Yeah. And of course, we've got record numbers of children school refusing at the moment. And the problem is always expressed as a failure of the parents rather than a failure of the school system or the support system. In this case, clearly it was the support system. This is why we're calling it institutionalizing parent blame, is that the default position is not to look at wider context of the huge mental health problems and the stresses that society is causing and the problems that schools are creating through desperately trying to get better Ofsted scores and things like that. It's always the parent's problem. And as you say, you have these extreme situations where parents are then prosecuted or threatened with prosecution, or police are turning up. Well, what the hell are police doing on an education matter? And this is the state not owning basically the problem. And the problem is always the automatic issue is this is a parenting problem. As we know, there's an organization I'm sure you all know of called Not Fine in School, which is just really looking at the fact that very many young people with autism mask, and so that they do everything they can to fit in school. I've already just said this. And they look fine in school, but when they get home, they explode. And the local authority then say, well, we think you're imagining this. We think you're fabricating this. This is a serious allegation because we haven't seen the child do this. And this is a sort of culture that we're encountering. So yeah, hopefully what we're saying in the research we're publishing will be of value to people like you, Rob, and saying, look, this is well documented that this is not the way to deal with these things. And if you said there were 2 questions. I don't know if Rob has any come back on that, or you said there was a second point as well.
Yes, there's another one from Claire. It says, I was denied an assessment by the disabled children's, but was passed to the FAST team instead with such damaging consequences. And when you speak up against them seeing the child alone, it's treated as a concern.
Yeah, and that's right. We've published a report on fabricated and induced illness, which is the allegation that used to, I mean, it isn't the same as, but it's a much broader concept than than Munchausen syndrome by proxy. And that if, one of the Royal College, we're having, I can explain this in a minute, but one of the indicators of that sort of behavior is you refusing to let the child be seen alone. But I mean, if you've got a child that has really social anxieties that are extreme, the one way to really traumatize them is to enforce them to stay in the same room as a stranger. And if the parent says you can't do that because it will traumatize them, they are then accused of a very serious accusation that they're fabricating this, or in effect that they are conniving in the child being abused. And it's got to stop. We're launching a very high-level campaign to change this. We insist on seeing your child alone. We blah blah blah, and there's going to be a lot of publicity about this fabricated induced illness stuff that we put on this note. This parent refused to let us see the child on their own, because before a local authority asks to see a child on their own, they must tell the parent what the cogent evidence is that the child is being neglected or abused. There's a presumption that I don't let any of my children or my grandchildren, stay with a stranger, whoever they are, whether they're a doctor or a police officer or anybody, unless they have cogent grounds for explaining why that's necessary. But the social services seem to think that it's the other way around. That a refusal to do that, even though there's no evidence given by the state as to why that is necessary, that it's just normal, it's a tick box. And in fact, our research shows that when a social worker goes out to do an assessment, whether it's simply of a disabled child or not, they have a box that has to be ticked that they've seen the child on their own. They're not given any discretion to say, well, I think this is entirely inappropriate. And that assessment has got to be signed off by a senior manager. So the pressure to do that is enormous, and the consequences, I mean, the families are placed in an impossible situation. And so we are heavily campaigning to change that, and we're using the language of discrimination. And the Equality Commission, Human Rights Commission, has recently met with us on this because it too is concerned. So I don't know if that's any reassurance or help. I think it's useful for families to know what their feeling is valid, and to make a complaint that they're the subject to a one-size-fits-all assessment process. They felt that they were navigating a system that was designed for child protection, when there isn't a shred of evidence in the local authorities' possession that the child was at a significant risk of harm. It's become so institutionalized, so normal, that even social workers are not pausing and questioning, why are they doing this? Isn't this fairly humiliating experience, an unpleasant experience for family and children? I don't know if there's any feedback on that or any other comments.
Yes, there's just some more just popped up now, Luke. Just before I read them out, Vicky, do you know your camera's on? Just to let you know, you will be in the recording. You might just want to flick it back off. Okay, so we've had a message from Viv. Excuse my coughing. She says, ours is 17, nearly 18. Is it better now to wait for an adult assessment?
Well, they need both. What we'll be talking about when we have the next session in July is that when a child is 16 or 17, adults should do an assessment. They should do it early enough to ensure that what the child's needs are will be met when the child becomes a young adult. So let's say if the child's needs are that they're going to need to move out of the family home into supported living, then they're going to need to do that when the young person's 16 or so, because that takes quite a long time to set up. But if they're nothing really is going to change significantly when they become 18. Then it could be when they're entering the 17th year. So obviously, Vicky should be asking for an adult assessment now, yeah. But also making sure that the children's assessment is adequate. Is that okay?
Was that all right, Viv?
Okay.
Yeah, I'll take that as okay. We have another one from Fee. Are we up against these barriers purely because LAs don't want to spend the money on services?
I think the financial problems of local authorities is a significant driver of this. It has exacerbated the problem. But I've been practicing since the beginning of time, basically. These problems have always these were a problem before the austerity hit in 2008, but they have become much more severe. So they're not purely, but they were latent and now they're patent. And they are across the board. We're seeing this in every English. With one or two honourable exceptions, every English authority is just buckling down, even though it makes no financial sense at all. And we've done research on the fact that these cutbacks are very expensive, even though children's services budgets have overspent by almost £1 billion last year in England, because the failure to provide early intervention support for disabled children, long-term intervention support, results in significant numbers of disabled children becoming looked after. The average price of a looked after child in residential care today is £6,000 a week. And for most disabled children, it's significantly more. So these are having huge cost impacts, but the local authorities don't seem to, the vast majority of local authorities don't seem to understand that.
Thanks, Luke. So we have a message. We have a message from Liz. It says, my daughter with ASD is currently on her 5th bout of early help. It doesn't work. She physically attacks me and it is due to overload caused by school.
Yeah. I'm so sorry to hear that, but I'm sorry to say that it's such a common experience. The only way is to really get support to challenge that. I mean, how absurd. I mean, the idea of early help is it's a one-off intervention for children suspected of being neglected or abused to resolve the problem. To have 6 bouts of, what is the definition of madness? It's doing the same thing over and over again, expecting a different outcome. I mean, this is absurd. So there needs to be a complaint made, but once you make a complaint, then it's like refusing a social worker to see your child on your own. It's another example that you're fabricating or inducing an illness. It's a catch-22, but my advice to families in this situation is to get social and emotional and practical support, and joining a parent care or support group is very, very important, because making a complaint is very isolating and so on. But so many families have to go through that process to get the system to sort of stop treating them, as a tick box exercise. And this isn't, I'm not criticizing the local authority here, it's a national problem.
Thank you, Luke. We have a message from Claire that says, thanks so much for your work surrounding this. We have a message from Michelle. My son suffers with very high social anxiety related to his autism and is entirely isolated as a result. No assessment for him, offered me an assessment but waited months. All about the process, no help on offer.
Yeah, it's very depressing. I mean, sorry, the young person wasn't assessed. Is that what you just said? Sorry, I've only remembered the second half. He's got very high social anxiety, very isolated. Did he have an assessment and then no offer?
No, he was refused an assessment. But
yeah, well, I mean, I think you have to go back and say, look, these are the facts. You know, I've been advised that legally there's a duty to assess his needs. He's become very isolated, blah, 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 and you need to make a complaint in that situation. On the accessing public services toolkit that I talked about at the very beginning, which you can download from my website, from the publications, there is a specimen complaint letter you can make. And one of them is a sort of touchy-feely complaint. You know, I don't wish to disturb the good working relationship I have with the local authority, but I'm forced to have to ask you to make a formal complaint because my son is in desperate need of support, and this has been refused. They've not only refused to provide support, but they've refused to actually assess him. I mean, how ridiculous. And if they say, well, he hasn't got any diagnosed condition, I mean, that's just plain unlawful. And we look at that in the report I referred to, which is called Institutionalizing Parent Carer Blame. And again, that's on my website. You don't need a diagnosis. You just need some evidence that this is neurodivergent behavior.
He attends a specialist school for autistic children, you know.
Well, you know, how ridiculous can you get? Yeah, how ridiculous. Clearly, he has a legal right to assessment, and you know, you just need to explain to them that you know your rights. You've been advised by Professor Clements, you can say. Is that okay?
Fantastic, thank you.
Okay, just a couple more from Claire, must be linked into the previous question. It says, having said that, when I do stay in the room with my child, my behaviours were still translated incorrectly and raised as a concern. And she followed up with, yes, it's really useful. The culture seems to be ingrained, as you say.
Yeah, we've got sorry, just on that, we've got a conference on the 9th of July in Leeds. We hold big conferences on these issues every year. This one looks like we haven't even publicized it yet and we're sold out, but it's online as well. So if you go to my website, when we do decide to publicize it, we'll put it up. There we're looking at these sort of issues, what we call system-generated trauma. Local authorities are all saying, oh, we're trauma-informed. We realize you've had abusive relationships, you were abused as a child, you have mental health problems and things, and we'll respond to that. What we're saying is that actually, for most families of disabled children, the abuse that they get, the trauma they experience, is from the way the local authority deal with them. It's not other things in their lives, it's the actual system that is generating it. And we're doing a short book on this. And so often you have these sort of presenting things that they won't let me see them on their own, the child on their own, or they did, but they were highly anxious. And then there's this sort of lovely comment, mum is anxious, as if that's a problem. But of course, if mum wasn't anxious, that would be a problem too, because, you know, they're not showing, you know, caring. But this idea that parents are anxious is a problem. Well, parents are anxious because the system makes them very anxious, and it's been created simply by the social worker, you know, having to agree that the parent can be in the room, and then the parent thinking, whatever I do, I'm going to be judged and criticised. So yeah, so we're talking about that in July. Bad luck, Claire.
Thanks, Luke. We have a message from Michelle. This could have just been answered. It says, how do we insist on a children's assessment?
Well, in the accessing public services toolkit at the back, there's a standard letter for a sort of template letter, precedent letter we suggest can be used. So that's probably the best thing to use.
Thank you. There was a follow-up message from Viv saying, yes, that was great for answering her question. Thank you. Okay. There's a message from Julia with just 2 numbers, 87. That could have possibly be just a typo.
Yeah, probably sounds like it. I don't know what 87 is. Maybe the answer to the meaning of life or whatever, but okay.
There's a message from Angela. My son is 7 and has a genetic diagnosis. We received visits from the disabled social worker, and after 3 visits, she said we are coping fine and discharged us. Despite my son's masking and his super social nature due to his condition, our family needs were not listened to, and we are left to fight alone for services or pay for opportunities privately.
Yeah, I mean, family coping. All that can be done is to say that we want to challenge that decision not to provide support. The evidence clearly suggests that this is not the case. So we want to go through the complaints process. We don't want to upset a wonderful relationship with that lovely social worker, but we do believe that it is essential that we receive some support because blah, blah, blah. Then you go through the complaints procedure, and there's a formal procedure, and that triggers it, and you're on the complaints conveyor belt, and the local authority then have to ultimately have an independent investigation, which the family can hopefully get their voices heard.
Thank you, Luke. A message off Jessica. What, in your opinion, to future solution? With cases rising and funding restricted for local authorities, it's difficult to see how the crisis can ever be resolved.
Well, I don't. Yeah, I mean, I'm going to try and be relentlessly positive. Disabled children, local authority children's services have 3 big problems. They've got a huge problem with special education, which is massive. Everybody wanting special education healthcare plans because schools are not meeting their needs. They've got unbelievably big problems with the cost of residential care for looked after children, which has just, gone berserk in the sense that this is costing them millions and millions of pounds. One local authority I'm dealing with last year spent £6 million on 5 children, £20,000 a week for each of the children. This has just gone absolutely crazy. So they have 2 huge economic problems, and they've got a tiny weeny problem about meeting the sort of community-based needs of disabled children and their families. And that is tiny compared to those other 2 costs. And so solving disabled children and giving them decent services is not going to be a big issue because its budget is tiny. The huge budget for children's services are special education and residential care costs. And those costs can easily be solved by making schools more inclusive. At the moment, they're excluding so many children, they're traumatizing so many children. If you just change the way schools behave, that would take the heat out of it. And if you gave early support and consistent support to a lot of families, interventions, which is what McAllister Review said, you would drastically reduce the huge numbers of looked after children who are traumatized in care far more often than they were traumatized living within their families. The state's very good at traumatizing people. It's very bad at providing residential care for looked after children. So all of these problems are soluble, but providing so decent support for disabled children is a tiny budgetary issue compared to the other 2. So it wouldn't take a genius to do that. To its credit, the government is piloting what's called family help, and I'll come to that in a minute. Now about 20 authorities. So these are not really budgetary problems because the cost of not meeting disabled children's support needs is very expensive because a percentage of those young people do end up looked after and some of those can be £1 million a year. So I don't buy that. I just think it's local authorities being really unimaginative. 2 or 3 authorities have been quite imaginative and have shown that it works.
Thank you, Luke. We have a message from Rob. It says, also, someone I know of was refused social care. Children in need help because there are other adults in the house who can help. These are siblings of the child and all have ASE even, or other diagnosis themselves.
Yeah, well, if those siblings are children, then that's completely unlawful, because we'll look at young carers in a minute. And there's no requirement that there's no duty on anybody to provide care for disabled children, including legally on parents, but there's certainly no duty on siblings to provide care. So how can a local authority say, well, they'd have had to have assessed those people and to show that they are willing and able to provide this care. And able would include, you know, having the skills, sensitive skills, you know, which may, because of their impairments, they may lack. So how can the local authority would have had to have done assessments of all of those siblings?
Just to add, those siblings were not children, so they are adults themselves. Yeah. But they are siblings. They are not the parents of, or you know. Yeah,
there's no duty. There's no duty on. We abolished the liable family rule in 1948, so there's no duty on families to provide support for family members. And the law is very clear. Carers don't have to provide or intend to provide care. And if a local authority is suggesting that they are able and willing to provide that care, they must have carried out a carer's assessment on each of those individuals to ascertain that they're willing and able to do that. And of course, if they are willing and able to do it, then the local authority doesn't have to meet the need. But it can't just say there are other people in the household, so we don't need to bother. Is that okay? Okay.
Yes, thank you very much for that.
Thanks, Rob. Thank you.
Well, thanks, Luke. Oh, are you okay to carry on? We've just got, they keep popping up. Sorry, Luke. Is that okay, or would you rather wait at the end?
Just do one more and then we'll carry on. We've still got an hour and a quarter or something, so we'll do one more and then we'll, at the end of this bit, we'll pause.
Okay, thank you. So there's one more from Vicky. I forced the social services to do an assessment and was told no help was given to be provided when I read her EHCP. They denied showing me the assessments, etc., until after the final evidence had gone through to the tribunal. Child in need minutes were withheld, and when I finally saw it, it was factually incorrect.
Yeah. I mean, this is getting into, there's nothing much I can say apart from the fact that quite a lot of our work at the moment is on looking at records that are the records that are held by local authority and health bodies, and the way that they are not faithfully recording information, the way that it appears that they are, it's very inaccurate information, and sometimes we question whether that inaccuracy was accidental. So yes, there is a real problem about records, and we are involved in a couple of people who are taking proceedings about the general problems with the data protection legislation. And that is a problem, finding out that things are on the file that really shouldn't be there. And things aren't on the file which should be there. Okay, we'll come back to any of those things. I'll plow on now. So the first issue is there's got to be an assessment. It's got to look at the whole range of issues, and it's got to make an informed decision about which needs are which it is necessary for the authority to meet. And the word necessary is used in the legislation, not exceptional or incredibly serious. It's just that the question is whether the authority thinks it is necessary to meet the needs. If the local authority says it's not necessary because there are carers there, then the local authority would have had to have undertaken a carers assessment to make sure that the carers are ready, are able and willing to provide that support. And we'll look at carers assessments in a minute. Once the local authorities decide that some needs have to be met, once it's worked out what we call the presenting needs are, these are the needs that the family and have said that they have. It's got to decide whether these needs are sufficiently significant, whether it's necessary for the authority to meet them with support, care and support. And that's the eligibility decision. Not everybody is going to be eligible for support from the state. So how do the authority decide which are eligible needs and which are not? And so every authority must have clear, transparent criteria about how it decides whether support should be provided or not. We've done extensive research on this of 152 English children's services, and not one, in our opinion, have eligibility criteria that are clear and transparent. There is a duty to publish this criteria in the local office, in the local offer. So the special education needs regulations specify that this must be published. And we've looked at these. And they are just completely incomprehensible. They have sort of big charts which are colored sort of red and blue and green and yellow, and they've all got horizontal columns and vertical rows, and they're all loads of indicators, but it's really very difficult to understand. That they're highly subjective. It's very difficult to understand whether somebody is at the end or not eligible. Often they're banded: 1, just open access; 2, local officer staff; universal services; 3, something; 4, urgent. But if you look at what you need to be qualified in the urgent, which is the red zone often, it's basically child protection, child protection, child protection. You know, it may have severe complex disabilities, but they've got to be really severe, really complex. And normally for a disabled child to get support, somehow they've also got to be seen as a safeguarding issue. They're completely useless, is the best word, generally. In adult social care, Parliament has laid down the criteria, and it's a simple 1 page. These are the issues. There's no reason why we shouldn't have a national, simple 1 page, exactly the same criteria for disabled children. And in Wales, to a degree, they've got it. It's not perfect, but they've done it as well. In England, Parliament has not spoken about eligibility criteria, so every local authority in a way rolls their own, and they are incomprehensible as far as I'm concerned. And I may not be the cleverest person in the world, but I think that if I can't understand them, then they're probably not good enough. So what is the problem? Looking at it more specifically, a quite common problem is some authorities state that only children who meet the criteria for an assessment by the Disabled Children's Team can access the whole range of supports that are reserved for disabled children under the Children Act 1989 and the Disabled Persons Act. Well, as I've already said, only about 2% of all disabled children are sufficiently impaired. They have complex and severe disabilities that they're dealt with by the Disabled Children's Team. So 98% of other disabled children are dealt with by the normal, MASH, safeguarding, early help, input team. So what these authorities are saying is, if you're not assessed by the Disabled Children's Team, you can't get all of these tailor-made disabled children's services. And then they say that it's virtually impossible for the vast majority of disabled children to be assessed by the Disabled Children's Team because it's a very, very specialist team. Now, there are 2 issues there. The local authority is deciding which children go to the Disabled Children's Team and which don't. And I think legally that's okay. I think they can make that decision because there's nothing in the law about this. So a local authority could have a very highly specialised disabled children's team just for very profoundly disabled children with complex needs. And I think that's okay. And that will deal with 2%. My concern is that the other 98% of disabled children must have an assessment by a practitioner who has got the skills to understand how disability differs with different impairments, or have access to somebody who can give them information about that impairment. And that team must itself also have power to sign off support services for disabled children under the Chronic Sick and Disabled Persons Act and the Children Act. It's simply unlawful to say that you can't get those services unless you've been assessed by a disabled children's team. That's the problem. And I hope I've explained that. I don't think we can insist which team assesses our disabled child. We can insist that whoever assesses our disabled child has knowledge of their impairment or has access to somebody that does have knowledge about impairment. And we can insist that that assessor can sign off support services for disabled children under these specific acts. It's simply unlawful to say that only children who meet the criteria for an assessment by the disabled children's team can access those services. That's wrong. Sorry, this PowerPoint's gone out of sync. Just restating that. Not only must every local authority publish information about its eligibility criteria for disabled children's services, but it must also publish information about what services can be provided to families under the Children Act and the Chronic Sick and Disabled Persons Act. Now, in the recent independent review, Josh McAllister said, we hear frequently that thresholds for support, both at Section 17 and early help, are very high. This point has been particularly raised by families of disabled children. Families struggle to get Section 17 services due to no safeguarding issues. Not providing support initially, families are ending up in crisis. We need a lower threshold for help so that they don't have to be in crisis to get help. So this is being sort of recognised nationally. And the McAllister review said eligibility for family help should be set out in a sufficient level of detail to give common understanding based on a range of principles. A national definition should also reference specific groups of children and families who might need help. And when it's talking about specific groups, it specifically mentioned disabled children and young carers. What we'll look at is that the big review that happened with the McAllister review a couple of years ago, which the government has accepted, said early help should be abolished, and because early help is just short term, and it said there should be what's called family help, which is not just short term. So going back to the point that disabled children can only access services if the disabled children team assess them. That, my view, that's unlawful, and the Ombudsman has said that as well. A few years back, the Ombudsman report concerned a parent who was experiencing considerable difficulties caring for a son who had genetic and developmental conditions, learning difficulties, pathological demand avoidance, and autism. They requested a parent carer needs assessment, and the authority said you can't get one of these because you're not being assessed by the disabled children's team. Only disabled children's parents who are under the disabled children's team can have a parent carer needs assessment. Well, that's just nonsense. The parent carer needs assessment, as we'll see in a minute, is the right of every parent caring for a disabled child. Full stop. Who's assessing that child is irrelevant. This was another local government ombudsman report it was a child with significant mental health needs in relation to whom there was professional acceptance that respite care was needed to prevent family breakdown. This was refused because his impairment wasn't sufficiently severe to enable him to receive support from the disabled children's team. In fact, the Ombudsman said, regardless of which team provides the care, the council assessed the need and it had to provide the support. So that's the end of the eligibility point. I'm now going to go back to care and support planning. At the very outset, I said it's about the how, who, what, and when. And now we're going to look at what these needs are. Sarah, are there any questions piling up whilst we get to this section? Or
sorry, Luke, one has just popped up from Luke, and it is a question. I'm trying to hold comments to the end, but this is a question. It says, can Luke explain what unlawful actually means in this context as opposed to illegal, and how unlawfulness can be fought?
Right. In a way, illegal and unlawful are synonyms. They're the same thing. When we're talking about crime, we often talk about illegal. And when we're talking about civil matters, i.e. matters that don't result in prosecutions, but court, we talk about unlawful. So, crimes are investigated by the police, unless you're the post office sort of thing. But generally, it's a police action, it's a magistrate's or a Crown Court action. Unlawful things are where you breach things like contract. But here we talk about public law. Public law places a duty on public bodies to do certain things. So the Children Act, the Chronically Sick and Disabled Persons Act, places a duty on authorities to provide support for people when they think it's necessary. And it says that this is the process. And if a local authority says, well, we'll do that, but we're going to add another hurdle, that's unlawful because they are putting in, they're putting a barrier between a person accessing these rights according to what Parliament says when they made the law, to what the local authorities decided, that even if they jump those hurdles, they've still got 3 local hurdles. Well, that's just not, you can't do that. It's an unlawful thing. So when I talk about unlawful, I'm talking about it in what we call public law, breach of these statutes that give social welfare rights, like education and social care and healthcare and housing and so on. How you access those rights is really difficult because, of course, the government, the last several governments, and it's not, have dismantled legal aid. So people have these theoretical rights, but accessing those rights are very difficult. You can go to the Ombudsman, and that's a free service. You can use the complaints procedures, which is a free service. And often that's going to resolve the issue. And as I say, the Accessing Public Services Toolkit that we've done is a good point of departure. It's a good starting point about how you can make complaints and go to the Ombudsman. So unless you're a very wealthy person or you are fortunate enough to find a legal aid lawyer that's prepared to take cases on, and there is legal aid, you're going to be needing to equip yourself with the abilities to make these complaints and ombudsman's letters. That's the normal route for enforcing civil rights. Civil rights are basically non-criminal rights. I probably explained that really badly, but hopefully that helps.
No, okay. That's fine. Thank you.
That's right. Thank you. Thank you. Yeah. So when we come to care and support planning, as I've already said, it's the how, who, what, and when, the fine detail. And a care plan really should be a very detailed specification. I don't know if I've got I always often liken it to a building arrangement. You ask somebody to come in and take a wall down or put a window in or restructure something or build an outside bathroom. And you could just say to the builder, well, look, just go ahead and do it. And it could all be verbal. But most of us wouldn't do that. We would want to have a really detailed specification drawn up about where this goes and where that goes and everything. Because if something goes wrong, and of course building work like social care normally does go wrong, you want to be able to point to something on the specification and say, you know, you didn't do this. This is clearly stated here and you haven't done it. So it's a sort of, it's a quasi contract where the local authority say, well, we accept we've got to meet these needs and this is how we're going to do it. And you need that spelt out with precision, with those sort of things in it. You know, Fred is going to have a personal assistant come and take him out or in the home. You know, how long, when, what days, what happens if the personal assistant doesn't turn up? Is it important that it's the same personal assistant because Fred doesn't like change? Is it important that the personal assistant's got training in applied behavioural skills because the ordinary personal assistant won't do that? We need all of those things spelled out because at the end of the day, the local authority will then have a duty to meet those needs specified. And sometimes you'll say, well, those needs specified can't be provided at £11 an hour because this person needs skills, it needs continuity so they don't keep coming and going because the wage is so slow, so low and so on. So it's important in the detail. And what generally happens is the longer a care plan runs, the more detailed it will become because people will remember that this is what you need to put in. So when you're thinking about a care plan or when you're given a draft care plan, you've got to really think about why things might go wrong, what we need to say to anticipate those problems along the lines of the list that you're seeing now on that slide. And that plan must talk about support services that the local authority is under a duty to provide. Now, they're under a duty to provide services under the Children Act and the Chronically Sick and Disabled Persons Act. Now, those acts have a sort of curious relationship, which you can read about if you download the Disabled Children and the Law Book, but they're almost inextricably interwoven. And when they're reformed, they will be just merged into one piece of law. But they cover a whole range of things like personal care in the home and in the community, personal assistant or support, community-based recreational services, respite short break services, largely focused on giving the usual carers a break. You can get direct payments instead of direct commission services. They include adaptations, equipment, fixtures and fittings. There's a real overlap between disabled facilities grants, which is a one-off grant for adaptations, but most disabled children's, if you need to adopt a house, often for disabled children, that is much more expensive than the maximum, the statutory maximum, which is 30,000, because you often are building an extension, which isn't normally the case for older people. So the local authority will say, well, you can have a disabled facilities grant of 30,000, but the family will say, but this is going to cost us 100,000, so we need 60,000. Well, you know, the local authority should tell you, but it normally won't, but that actually that additional money can come under the Chronic Sick and Disabled Persons Act, Children Act duties. Travel to community-based services. So if a young person needs, it's identified that there's a community-based service. The question is how they're going to get, you know, have they got wings? Do you have a helicopter? No. Well, how are they going to get there? I mean, it may be that the parents are willing and able to drive them there, but that shouldn't be assumed because there's no obligation on them to do that. And the reason they're in the community is probably to give the parents a break. Well, they're not going to get a break if they have to drive the child there and back, and so on. And once it's been assessed that there is a disabled child, whether that child's eligible for services or not is irrelevant. Once it's accepted as a disabled child, then the parent must be offered a parent care needs assessment, and we'll look at that a bit later. So looking at some sort of specific disability-related support issues. The Children Act says that every local authority should provide services designed to minimise the effect on disabled children within their area of their disabilities, to give such children an opportunity to lead lives which are as normal as possible. And then you see that little C there. It says to assist individuals who provide care for such children to continue to do so, or to do so more effectively by giving them breaks from care. So this is what we talk about, short breaks. And that's 1C, schedules to the Children Act. That is fleshed out, that last paragraph, in regulations. Oh gosh, I see, I've made a mistake here. I thought I had. Can I just amend my PowerPoint quickly? So that's out of kilter. Right. Ignore everything I've just said. I'll come back to it in a minute. I just said this, that there's a whole range of support services, and I looked at personal care, respite care, direct payments, adaptations, and so on. The first thing I needed to say after that is, on that list, there's no reference to a thing called early help. And that's because early help doesn't exist. It's not a legal, it doesn't exist within the law. It's not mentioned in any legislation at all. And in fact, early help was created because of the Victoria Climbié inquiry, the Jasmine Beckford inquiries. It was created by Lord Laming and Eileen Munro in their abuse inquiries, saying that there needs to be short-term interventions where children are being neglected or abused to see if it can be corrected. So early help was purely and simply created as an idea in abuse inquiries to protect children who may be at risk of neglect or abuse. And it was to protect them becoming children in need. It's got nothing to do with disabled children at all. It's entirely inappropriate to refer a disabled child to early help, unless there's really there is significant evidence that that child is being neglected or abused. Because the idea of early help is to prevent children slipping into being children in need. Well, children in need, disabled children are already children. So in our institutionalizing parent care blame, we look at the genesis, the derivation of early help, and show conclusively that it's entirely inappropriate to refer disabled children for whom there is no cogent evidence of neglect or abuse to early help. And the McAllister Review basically accepted that. It said, for families who need help, there must be a fundamental shift in the children's social care response so that they receive more responsive, respectful, and effective support. To reduce the number of handovers between services, we recommend introducing one category, i.e. abolishing early help and creating family help to replace targeted early help and children in need work, providing families with much higher levels of meaningful support. Josh McAllister thought that would cost about £2 billion a year. The government accepted his recommendations, but has only put in 1/10 of that sum, 2 million, not 2 billion. If that was fully funded and done, that would solve most of the key problems for many disabled children and their families, and it would massively reduce the huge costs spent on looked after children. So we're back to this bit, which I mentioned just now, that the Children Act says that there must be support services for disabled children. And in the final little c paragraph there, it says there must be support services to assist families who provide care for children, disabled children, to continue to do so more effectively by giving them breaks from services. That's fleshed out by regulations, which are called the short break regulations. And that's in performing that duty under section 61C of the schedule, local authorities, this is providing short breaks. Local authorities must have regard to the needs of the carers who would be unable to continue to provide care unless breaks for caring were given to them, and must have regard also to the needs of carers who would be able to provide care for their children more effectively if breaks for caring were given to them, to allow them to undertake education training and any regular activities, to meet the needs of other children in the family, carry out day-to-day tasks which must be performed in order to household. So the first thing we've got to realise is that short breaks are for the parents. They're not for the disabled child. And that seems to be so often misunderstood. And I think it's not, because social workers, frontline practitioners are not trained in the law. I don't think it's them being naughty. I just think they're not simply aware that the whole point of short breaks is to give parents a break from their caring responsibilities so they can do other things. It's not to provide meaningful activities for disabled children. Obviously, the short break will involve the parents having a break so that the activity needs to be appropriate for the child. But the primary purpose is to give parents a break. And I've been told, by very well-meaning, genuinely nice frontline social workers, of course, short breaks are for the child. And you say, look, I'm sorry, if you look at the regulations, it's just not true. That's for the parents. With direct payments, the legislation says that parents of disabled children, if their child is eligible for support, can say, I don't want you to commission the support or provide the support yourselves. I want a direct payment and I'll sort it out myself. The default position is that parents have the right to have a direct payment instead of the services. They've got a choice as to whether they have direct payments. And if they exercise that choice, then that's all. They don't need to give reasons, or they can't be refuse them unless there's evidence that they're unsuitable and will spend the money on gambling or something. But that's got to be hard evidence. So there's a choice. And if the choice is that we want the money, then that's the end of it. So once the local authority has decided that the person is eligible for non-residential care, so you can't get a direct payment for residential care, then subject to certain conditions, it can be required to provide direct payments instead of services. So it's unlawful for a local authority to have a policy of refusing direct payments for certain services, say, well, you can't have it for respite care because we've got a block funded and therefore you've got to go there. That was said in a Staffordshire case. Or you've got to give us reasons for wanting a direct payment, and that was held to be unlawful in the Swansea case. Or it's unlawful, and it's also unlawful for local authority to insist that families have a direct payment. The basic obligation is the local authority has got to meet need, and it can't, as it increasingly does, say, well, it's a bit awkward. We just can't provide this service because it's too complicated. So you'll have to have a direct payment. Direct payments should be a positive choice. They can't insist that individuals feel that they have to have a direct payment and sort all those things out themselves. So this is a case we were involved in. Of a parent, and she complained that the early she had a child with significant impairments. She was being dealt with by early help. She didn't like that, but she put up with it. And they said, well, we're going to place this young man in a day centre. and the mother said, look, this is totally unsuitable. He hates the day centre. I have to force him into the car, and he tries to get out of that. When I get to the day centre, I have to drag him in. When he's there, he's physically restrained. They lock the door so that I can get away. And it just leaves me traumatized. And the local authority said, oh, well, no, because he calms down afterwards, which is an interesting idea, you know. It's just the handover. And she's saying, look, it's traumatizing me, and I think it's traumatizing him too, just because he calms down. I think he's just masking. The local authority said, yeah, we accept your son's disabled, but he's not disabled enough to warrant assessment by the disabled children's team. Again, the same hymn sheet, basically. And unless you get assessed by the disabled children's team, you can't have a direct payment. And as I've already said, just sort of reiterating, they've got these criteria, which is really 4 levels, which is quite common. But you had to be level 4 to be in the disabled children's team. So level 1 is universal help, which is, in my opinion, generally no help at all. Level 2 is early help, but they're time-limited short-term interventions with a very limited menu, a bit of respite care, time-limited or parenting support. Level 4 was intervention required either because there is a child in need or a child in need of protection, or one that had complex needs and disabilities require specialist services. And they were saying, didn't fall into that. He wasn't so complex. And they said only children in level 4 were eligible to direct payments, which is nonsense. Any disabled child, if they're eligible for support, and this young man was because he was going to a day centre, if a disabled child is eligible for needs, then they can say, look, this isn't what I want direct payment. The Ombudsman said that. And the Ombudsman said, maladministration, it's unlawful. He held that the child was entitled to direct payments under the Children Act 1989 because he is disabled. I don't like it, but that's the law. The duty to meet needs is a non-resource dependent need. What that means is once a local authority has decided that somebody needs something, for example, 10 hours personal care a week, then it's got to meet that 10 hours. It can't trim the support package because it's got financial problems. Once it's decided that somebody is eligible for support, the duty crystallizes and it's got to be met, regardless of how poor the local authority is. So that means there can be no maximum charges. And this is a statement in relation to adult social services, but it applies just as much to children's services. This is in the statutory guidance to the Care Act. It says, a local authority finances are relevant when it decides how to meet needs, but not whether. So if there's 2 ways of meeting a need, a local authority can choose the less expensive, but it's got to meet that need. And this is an Ombudsman report that said, it's incorrect to state that budgetary constraints are a legitimate reason for not meeting the identified support needs of a disabled child. Each person within the council's area must be assessed on an individual basis and their needs met accordingly. Budget constraints must not dictate the level of support offered. Okay, just a few winding up points, and then we'll move on to parent carers assessments, which is the last thing I'm going to cover today. I've got quite a lot on my website, and there's quite a lot in the Accessing Services Public Services Toolkit about funding panels. They are very common these days, and in my view, they are legally very dodgy. What happens is that you have a social worker or social care practitioner come and assess a family, talk to the family, see the house, see the children, and they use all their professional skills in that process, and they decide that there is a need for this, that, or the other. They then say, well, actually, I don't make this decision. It's made by a funding panel. And normally they're not called funding panels. They're called allocation panels, or all sorts of weird and wonderful names to mask what they're doing, which is really rationing. So the social worker's recommendation goes to the panel, and the panel then says, well, you know, cut this. You're saying 10 hours. We have decided that only 6 hours will be offered, something like that. And what the courts and the Ombudsman have is a problem with that, because something like 75% of all the information we take in, most people take in, is visual. So this social worker, this care practitioner, has seen the family, used all his or her senses in assessing the risks and the issues and the needs, and they've come to a conclusion that it's necessary to provide this based on that experience and that knowledge. And then a group of people who've never seen this child, or not seen this child for more than a few minutes, few months or years ago, a group of individuals who've got no current detailed knowledge are countermanding that decision. And the courts and the Ombudsman simply say, what was the reason they countermanded it? What was the evidence they had that overruled this person's assessed decision? It's like a doctor saying, I think you need to go and have a test for, you know, this because I think it's potentially cancerous. And the hospital saying, no, we don't agree with the doctor. We have never seen this person. We don't know anything about it. We've just said no. I mean, you can't do that. The one person that's got expertise, that's looked at all the factors, has recommended this. And it can only be countermanded if that panel has information, relevant information, that overrules that. Normally it doesn't have it. The panel is there simply to ration and keep in budget. And so there's a lot of court and Ombudsman's decisions on panels saying that this just isn't on. And in the adult care legislation, the statutory guidance is very good about this. It says, yeah, you can have panels, but really, you know, they would be appropriate to sign off large or unique personal budget allocations. So if you're talking about a home care package of £5,000 a week or something like that, then surely you'll have senior officers to try and, you know, see if it could be met more efficiently some other way. But it then goes on to say, and this is the government's guidance, where used panels should be appropriately skilled and trained, i.e. they should be skilled practitioners. And authorities should refrain from creating or using panels that seek to amend planning decisions, micromanage the planning process, or in place purely for financial reasons. I mean, some authorities require everything to go to a panel, which must be micromanaged. So there's a couple of slides there. I'm not going to go through them because I need to catch up. But if you look at if that's of any interest, then there's a lot of information on my website and the Accessing Public Services Toolkit about that. Simple point, I'm not sure how relevant it is, but normally a local authority, if it commissions a service, won't provide it itself. It will commission a private provider or provider to do that, and a day centre or a community-based care service or something like that. They can contract out responsibility for care delivery. But as the Ombudsman said, they cannot contract, or they can contract out the delivery of care, but they cannot contract out responsibility. Poor quality care by a council-funded provider is poor quality care by the council itself, and therefore, if a provider has provided suboptimal care, the complaint goes to the council, not to the provider. Right, I've only got a little bit more on parent care assessments and young care assessments. So I don't know if there are any more comments. Or
yes, just let me just have a look how far we need to go up. Okay, there's just a couple on this and this latter part. So there's one from Fee. It says, what kinds of services / support can be given by the child with disability team? I'm currently in this situation, being denied assessment by the child with disability. So under FAST team with children in need meetings and early help brought in, but our needs are around support to access activities in community, social isolation, etc. It might be easier for Fee to explain that herself if that's confusing.
Yeah, I'll respond and Fee then come in. I've forgotten what FAST stands for. It's the I'm familiar with MASH, which is the multi-agency safeguarding hub. So FAST is obviously, you can tell me what it stands for. But it's the point I've been making, I've tried to make, is that it doesn't matter which team you're with. That team must have the power to provide community supports, socialization supports, adaptations. It's got to have the power to sign off all of those services. So simply because you're not being assessed by the disabled children's team is irrelevant to what support can be provided. Now, your authority seems to be saying that you can only get the sort of support you need if you're assessed by somebody else. And that, to be blunt, is a word that rhymes with rollops. It's simply not the case. And if you have that need, whoever's assessed you should be able to sign off that need if you've spelt that out. Fee, does that help?
Yes, I think your slide actually answered my question, and the one that sort of said about adaptations to the home, direct payments. I think basically we've encountered the problem you've been talking about, and as far as I know, the FAST is family assistance and support safeguarding team or support team. So we've ended up down that trajectory, and I've been fighting for 12 months saying, look, I don't think this is right, and they're insistent. But although there's the local authority telling me that I can access these other services, they're just not. I think the mindset is on this different track, and so they're just not expanding the thought process to cover what else can they offer other than early help. So I think I've got ammunition to go back now. Thank you.
They've got a blinkered approach. We can only deal with these things. It's like. And of course, you can access the whole menu. It's not, and they're saying, well, you can only access the menu if you go to this place. Well, that's just not true. And you can't go to that place anyway, because they're saying your child isn't being assessed by this, because presumably they don't meet the criteria. So yeah, hopefully you can. And one of the complaints could be made that I may have misunderstood what you're saying, but clearly what you are saying, what I understand you to saying is I can't access these even though I've been assessed, and I believe that's unlawful.
Well, they're not saying, they're actually not saying the unlawful bit. They're saying that even though I've gone down this track under FAST, I can access the other services, but they haven't mentioned any other services. They've just put in place child in need meetings and early help, and also they will not give me anything in writing to say, the conclusions of the assessment they've carried out, the needs they've identified.
Okay, so the complaint is that they haven't provided you with a decision on a reasoned decision on eligibility for these services, and they haven't provided you with a copy of the assessment, because they should share the copy of the assessment. But you haven't had a finalised assessment. That you basically, the whole thing's just in limbo. And they've had adequate time to complete the assessment, to explain what my needs are and what they're not. And since I made it clear that I want this service, there should be a clear statement of whether I'm eligible or not, and if I'm not, reasons why that isn't I'm eligible. The whole process is stalled, and with the greatest respect, I think the only way I can get things moving is by making a formal complaint.
Well, I've done that. I'm in stage 2. There's a big investigation going on, but it takes so long. Luckily, I'm in an appeal window, so I think I'm just going to put an appeal in,
Yeah. I mean, hopefully the stage 2 will have an investigator who isn't, who does understand these things, and it will resolve it. Otherwise, you'll need to go all the way. You may need support for that. Yeah.
Thank you. That's helpful.
Yeah. Best of luck.
Thank you. Thanks, Fee. Thanks, Luke. Are you happy just to answer a couple more?
Yeah.
So we've got a question from Rob. He's got 2. So the first one is, are short breaks respite means tested?
There's no reason why local authorities are allowed to charge for children's services. So in theory, local authorities can charge. Only very, very few local authorities do charge. And in order for them to charge, they have to have consulted on that process. They would have had to have done a quality impact assessment process. Very, very few authorities do charge. Now, what I was going to say to Fee, but I hesitated, but I'll say it to Rob. If your child's got an impairment that is what's called neurological, so Cerebra is a charity that deals with children with neurological impairments, not just simply physical impairments. But if in any shape or form that is neurological, and if the young person is under 18, then you could contact the Cerebra advice line, the one that I supervise. It's quite busy, but we have had a particular issue running with North Yorkshire on this issue of charging. And I know it's come across I've been asked to look at it and I've given advice on it. And so that team is looking at that issue. The authority seems to have done something quite unusual, which I don't think is lawful. And the team is aware of that issue, but generally short breaks are not charged for, no. If the young person is an adult, then there are different rules.
Brilliant. Okay. Thank you, Luke. Are we happy for just another one?
Yeah.
And another one from Rob is put, can Luke confirm that when he talks about care plan, he means EHCP as in the health side of an EHCP?
No, I don't. So I'm obviously avoiding today talking about education healthcare plans because I'm not an education law expert. I understand the basics, but not the fine detail. When I'm talking about a care plan, I'm talking about the social care plan, the part in H of the which is the Care Act and the Chronic Sick and Disabled Persons Act. My view of education healthcare plan is it's a bit like the Eurobus construction system, where the wings are built in North Wales, the engine is built in Berlin, and the fuselage is put together in somewhere in France. That in fact, an education healthcare plan isn't some sort of wonderful composite thing. Social services, children's services put together the care plan. The NHS, in theory, should put forward the health plan, but of course they seldom do. And the education element of the plan is put together by the education department. And those things are really just bolted together. So what I've been talking about today is the social care part of the plan. And if you have special education needs, that will just be slotted into your education care plan. And when you become 18, it will be pulled out and the Care Act adult bit will be pushed in if you have education needs up to training and needs up to 25. So this isn't, the education, and I'm sure everybody knows, is education healthcare plans are not holistic. They are just three separate elements bolted together, the most important of which is the education, because without the education bit, you don't have you can't have a education healthcare plan.
Can I just confirm? Because I think I put health by mistake actually.
Okay.
In the HCP context, I'm talking about section H, which is social care vision.
Yeah.
So it is that side of
that bit,
the same thing.
So,
okay, right.
So yeah, that's right. So most disabled children don't have an EHCP plan. The ones that do, but they should also. But most disabled children should have a care plan that explains what their social care needs are under the Care Act and the Chronic Sickly Disabled, the Children Act and the Chronic Sickly Disabled Persons Act. If the child gets an EHCP plan, then that plan is just bolted on. Yeah. So yeah, you've understood exactly what you're saying.
So there could be a separate social care plan in isolation, and
that
can be added to it. Yeah. Right. Okay.
Yeah. Sure. Yeah. EHCP plans are quite new. Because social care obligations have existed since 1948. Yeah.
That's great. Thank you.
Thank you. All right. So I'll wrap up with these, and then if there's any more questions before we get to 12:30, we can cover them. So what we see is that parent carers have a right now to an assessment of their needs, their well-being needs being met. Now, this duty to undertake these assessments is now in what's called Section 17ZD of the Children Act 1989. Now, what happens is the Children Act 1989, when it was initially enacted, didn't have anything about parent carers. It had Section 17, which is about disabled children, but that section's been much amended, and it was amended by the Children and Families Act in 2014, which slotted in a new obligation, but that obligation is now located in the Children Act. So if you're asking why you haven't had a parent carer needs assessment, you would just put, an assessment under Section 17ZD of the Children Act 1989. And what that provision says is that all parents of a disabled child have a right to an assessment. Full stop. Not parents who are providing unusually large amounts of care or anything like that. It just simply says all parent carers have a right to an assessment. They don't even have to ask for it. They should be given an assessment as soon as the local authority is aware that they have a disabled child. And a parent carer is an adult who provides or intends to provide care for a disabled child for whom they have parental responsibility. So a very wide provision. All parent carers of disabled children should have this. And the assessment must have regard to the well-being of the parent carer. Now, well-being is defined in the Care Act, curiously, which is an adult legislation, but what the parent carer needs legislation makes clear is that well-being is the same. It covers the parent carer's personal dignity, their physical health, their mental health, their emotional health, protection from abuse and neglect, control over their day-to-day life, education, work, training, work. Parent carers have a right to work. They have a right to stay in college. They have a right to undergo training because they may want to, if they're not in work or full-time work, may want to upskill and go back to work. They've got a right to social and economic welfare in the sense of having enough money to pay the utility bills and put food on the table. They've got a right to have personal relationships. So many of them are single parents. They've got a right to suitable accommodation, and they've got the right to be able to contribute to society, to get involved in local activities and so on. And when they're deciding about these issues and how they relate to well-being, there's a whole series of things the local authorities should consider. And I think, in a way, the most important of that list is the first one, that the individual is best placed to judge their well-being. So if an individual says, look, I want to stay and work, so I need support to let me stay and work, then it's not for the local authority to say, well, we don't think that's good for you, because it's the parent carer that has to do that. And so often I come across local authorities that say, well, it's not our duty to provide support for you to go to work, or so you can stay in work or whatever. And you think, well, I know that the frontline staff are not trained in the law, but that's just wrong. Because as you can see there, that is spelled out very clearly in the well-being criteria in section, to which the parent carer's needs assessment was of regard. And there's a very good report that I think sums this up, which is an ombudsman's report in 2016. So this is a single mother, and she's got 2 children, one with significant disabilities, and he needed constant supervision. And that was completely, everybody accepted. The council said that it expected parents to organise their work responsibilities around the needs of their children, that it was not the responsibility to provide direct payments solely to enable the parent to work. And I say that is said very often. And where do they get that from? Because the parent carer needs assessment clearly says that they have a right to work. I mean, obviously councils expect parents to try and make arrangements for their childcare, and councils are not responsible for that. But if standard childcare arrangements are not available because the child's impairments are such that the respite care, the after school club, the playgroup won't take the child because they haven't got the skills to meet that child's needs, that's an additional impairment created problem that the family have, for which children's services exist. If the core responsibility of families was to meet their child's needs, then there wouldn't be a need for disabled children's services. There wouldn't be need for any legislation, but that legislation all says that parents have got a right to do these things. And if those things aren't available simply because the child's impairments are such that it's not catered for, then that's the responsibility of children's services to provide it. The council said, but we will be helpful, i.e. they won't be helpful. What happens was that she was getting a weekend break every 2 weeks. She had, I think, 1 or 2 nights overnight respite care every 2 weeks in the school term. And so they were saying, if you forego all of those 2-week breaks, those fortnightly breaks that we fund you during the term, and you store them up, you can use that time in school holidays so that will give you some ability to be in work. So the local authority wasn't doing anything apart from being slightly flexible. But the cost to her was enormous in the sense that she wasn't going to get any breaks at all during term time. And then the Ombudsman said that that's maladministration, which is effectively unlawful. The council just didn't understand the law. The child's assessment and the carer's assessment should feed into each other. They're interwoven, and once you know what the child's needs are, then you can understand the challenges that the parent has. The council knew that the child needed constant supervision. It also knew that she was in full-time work, and the nature of her job meant that she couldn't get flexible working. These are key factors, but neither the son's assessment nor the carer's assessment properly considered those issues. Government guidance is very clear that authorities cannot assume a carer is happy to continue in their caring role. Council is required to consider whether the carer works or wishes to work. Nothing in the assessment suggests the council would probably consider the impact on her if she didn't receive the support during school holidays. That decision should have been really taken on board by every English Children's Services Authority, but time and time again we're coming across exactly the same problem as this parent experienced. Brief. Yeah, one of the problems with the legislation, going back here, is that the duty to assess a parent care only applies to adults who have parental responsibility for the child. What about somebody who's providing a lot of care for the disabled child, but is not got parental responsibility? An unmarried father, a stepfather, or a grandparent, or another family member or friend. They do have rights under the Carers Recognition Services Act, Section 1. So that covers that loophole for people that don't have parental responsibility. Parental responsibility is something you get normally a bit, well, you get if you're the mother of a child, or you're these days you're the acknowledged father, or even if you're not married or on marriage. Assessing young carers, and there's a mirror image responsibility, so that's under Section 17ZA. Again, young carers don't have to ask for this; they can be assessed on what the parents need. The young carer is a person under 18 who provides or intends to provide care for another person, full stop, as long as they're not paid for it or formal volunteers. The very detailed assessment regulations, I think they're much too detailed, actually. But young carers do have these rights. And the point about young carers is that they shouldn't be providing inappropriate care. So if a young carer exists, the whole idea is that is evidence that the care plan is not working. And therefore additional support should be put in place so that the young carer ceases to be a young carer. Effectively, we want to just annihilate young carers by just stopping them having inappropriate caring responsibilities so they can have a childhood without that. So I think we're pretty well there. Yeah, there's huge regulations. I think they're much too detailed. So, colleagues, got to the end of this. We've got, as I say, another session at the end of, towards middle of July, something like that. Any more comments, questions, issues raised?
Thanks for that, Luke. Okay, yeah, there is a few popped up. I don't know whether it might be easier for you to open the chat because some of them are quite long, so it might be easier for you to digest them. If you let me know when it's open, when you've opened it, I'll show you where we got up to.
Okay, I've opened it now. I'll start at the bottom, shall I, and move up?
Okay, if that's easier, yeah.
All right, so I start at the bottom. Sorry, I can't. Okay, no, I better start the other way around. Where are we?
Okay, so if you go to Vicky's message at 11:05, I've read that one out. So the next one is Daniel Cooper. He's just put a comment in at 11:07.
Yeah,
that's where
thank you, Daniel. Yeah, yeah, systems generated trauma. This is exactly it. I was talking about the conference, wasn't I? Yeah. Yeah, we're saying, I mean, I think it's such an interesting issue. Most of these authorities are producing these trauma-informed practice. We're incredibly concerned about external traumas that families have experienced. And we're saying, well, they've got to have in that document the fact that what they're doing is traumatizing sometimes, you know, unintentionally sometimes, but they've got to acknowledge that what they do is traumatizing. Okay, Jessica, 11:08. We've been in the broken system for 8 years now. After 2 tribunals, 2 children have severe mental health challenges due to unmet needs and have no education. 7 complaints, all stage 2 to the local authority, all upheld. The family is broken, helpless. Both have ECHC pays, but the local authority don't have resources to put what is needed. Yeah. Legally, the local authority's got to put those resources in. They can't say that we don't have it. They've got to meet those needs if these can be upheld. I'm really sorry to read that. I wish it was the first time I'd ever read something like that, which it's not, of course. Some of these dispute procedures, like going to complaints and going to the ombudsman and going to the information commissioner, they don't, local authorities have said, yes, we're very sorry, but then they don't implement these things. You're getting to the stage where you probably need a lawyer in those sort of situations. There is still legal aid for children to take proceedings against local authorities. That the problem is not, so legal aid does exist in those cases. The problem is finding somebody to help you. The local authority has got to find those resources. The local authority can spend £1 million on one child if it needs to, and there will be many children in your local authority area whose packages are possibly 10, 15, 20,000 pounds a week. So the local authority, if it has to, can do this. On my website, I've got a resource, not perfect at all, but it is find a local lawyer. There are lawyers in this area. There is legal aid for disabled children's cases. I can't probably say more than that, Jessica. I'm really sorry to hear what you had to endure. Yeah, I mean, Claire, that's a really... I was told to get support from my child who couldn't leave the house from another mum in the village. I mean, how stupid. What's the point of children's services if that's what they say? Just go and ask a neighbour. I mean, that's existed since time immemorial. What was the point of passing the legislation? It's not good enough, as you well know, and I'm sorry about that. The Ombudsman's just found a case in which we went against the Ombudsman and general requirement for good record keeping, but the penalties are tiny. Safeguarding is a bit like a data protection, is often turned around and used as a threat for a reason. Can Luke explain what unlawful? Oh yes, I've already done that. Yeah, Rob. I mean, we despair of the Ombudsman sometimes and the Information Commissioner. There's not, they can be a force for good, but their budgets have all been cut by about 80% in the last 10 years. It's not an excuse, but they quickly lose interest after having made a decision. What kinds of services support can be given by the child with disability problems? Yeah, we've looked at that, haven't we? Yeah, I think. Can Rob the slides be sent? Yeah, Rob. Can the update slides? The slides you've got are slightly different to the ones that Sarah circulated, but only in terms of sequence. I've moved some of the slides around. I haven't changed any of the slides, I don't think, but if there's a problem, let me know, or let Sarah know, and I'll sort that out. Our short breaks needs us to be looked at that. The funding panels quite often refuses our requests, but they never justify why they do. The funding panels have got to give reasons for their decision. There's quite clear case law on that. They've got to say what the recommendation was from the social worker and their reasons for their decision. And I think that's on one of the slides. I slipped. When I was looking at panels, there was a slide there which a couple of slides I jumped over, but one of them did say that, and it's a local authority ombudsman's decision. So, Julia, statutory short breaks, where there's an assessment and if Section 2 eligibility is required to be met, direct payments are provided. 2, short breaks grant, which is discretionary, means tested, not to be applied for via a form, and panel decides who gets the grant. Yeah, well, that's just nonsense. I mean, this is what we've had in the Liverpool case. I mean, if you need a short break, then you need a short break. And that will have been assessed under the Children Act. And they're sort of saying, well, short breaks aren't under the Children Act or the Chronic Sickness and Disabled Persons Act. Well, what are they under? And the answer is they are under the Children Act. And that's, if you look at the slides, when I looked at that, the Ombudsman said, look, the child's a disabled child under the Children Act. They've been held that they need this. Therefore, it's got to be provided. They're not discretionary.
Sorry, hello, it's Julia. I think it's a sort of distraction. It distracts people from applying for a proper assessment. So it's offered as a grant that's an easy, accessible way of getting some money for a short grant, but they don't advertise. They advertise them as though that's the only thing available, which then parents go down that route, and then they sort of get deflected from going down the official route, which is to, as you say, be assessed under the law.
But I mean, the question is, I mean, in a way, if you get it, get it. But the question is, under what bit of law are they providing these short breaks? And they're saying, oh, it's just a grant. Well, the answer is yes. Well, local authorities get grants, get huge grants from the government for all sorts of things. But under which bit of law? Are they saying it's a charitable grant? I mean, the local authorities are not charities. They are statutory creatures. They can only do what the law allows them to do. So which bit of law is it that they're providing you under this? And
I think it's to address the issue that they're supposed to be providing short breaks, to the majority of disabled children in the area. So that's that sort of tick box that we offer a short break system. But then very few families, as you've heard, go through the formal assessment process and assess whether or not they meet those legal tests. So it's.
But they must be given some. Yeah, I mean, the point is that the local authority just doesn't understand what it's doing. People can't just say, I want a short break. They'll have to satisfy some criteria. Presumably the local authority will want to know that they're a disabled child. They will want to know certain things. And once it's satisfied that they're a disabled child and those things, they've done an assessment. They might say it's not a Children Act assessment. The question is, but it's an assessment under what piece of legislation? You're a creature of statutes. You only do what statute allows you. Which statute are you doing this under? The Children Act says that effectively when a local authority knows that there's a disabled child, it must assess them. So why haven't you assessed them? Because they must be disabled, because that's the only way you can. The point is that it's a form of confusion that doesn't bear over inspection. They don't understand what they're doing, or if they do, they are not being entirely frank. And it's when, that's what happened in the Liverpool case. They just said, well, this is short breaks, it's not Children Act. And the point is that short breaks are Children Act. And they're saying we've got a quick and fast process. Well, that's fine. You can have a quick and fast process. You don't have to have a full assessment. You can have an assessment, that's very fast. And very, very brief, but it's still a Children Act assessment. If you've got a fast track process for something that, well, that's fine. It's hunky dory. You don't have the ordeal of being assessed, but it's still a Children Act service. So
I suppose my point was more that they're not identifying people with higher level needs. So they're effectively fobbing people off with a small grant without actually assessing whether their needs might be higher than what the grant allows for.
Yeah, and that follows. Yeah, that's an additional and very important point. Yeah. So Sue's asking about the duty to protect the family purpose. I'm not really going to go into special education. There is a provision in that. You're going to need to, what you say, just about the person in reference to finding suitable education. Well, it's not actually expressed that way, is it? It's got to be efficient use of public resources. The local authority's got to meet the need. There are sometimes the local authority says we meet the need by putting you here, and the family say we don't want that because we want the more expensive one. In those situations, the family's got to show what the local authority proposal, why it won't meet that young person's needs. And very often because the young person won't settle there, they won't like this, there's all sorts of reasons why it doesn't meet the need. And in that case, the local authority isn't choosing the cheaper of two options that meet the need. They're choosing one option that doesn't meet the need. And if there's only one way, and if that doesn't meet the need, then the other one is the only way that can be met, and so you've got to choose it. So often, you say to the family, why are you wanting to use a more expensive option? And they're saying, well, it's because what the local authority is offering, it doesn't do this, this or that, and the child doesn't like it. Well, those are all relevant factors in assessing the need. And if you say the need is that they have to do this, this, and this, then you say, well, that offer from the local authority doesn't meet that need. I'm sorry, I'm racing a bit now because we're up against time, but very often the local authority isn't choosing the cheaper option. They're choosing an option that doesn't actually meet the need. So I think most of them are, yeah. I think we're there then. I think it's probably time to wind up anyway. Thanks everybody. Thanks Sarah for all of the help and colleagues in setting this up. Is that okay?
Thank you so much for your time, Luke. That's really appreciated. Once we've edited the recording, we'll make that available on our website and send the link out to everyone if they want to listen to the recording. And the next session is Thursday, the 18th of July, same time, 10 till 12:30. We'll publish that on Eventbrite over the next couple of weeks. Okay. But thank you everyone for attending. Thank you, Luke. That was fantastic.
Yes,
That's
thank
great.
you.
Thank you, everybody.
It's been really helpful.
Have a good day.
Right, okay.
Bye
now.
Bye.
Thank you. Bye-bye. Bye.